Nisha Tekwani, CA Chola Thakkar, CA Suvrit Shah, and Advocate Dipesh Shakwala onto the dais. Let me take this opportunity to brief you all about Senior Advocate Tushar Hemani sir. Sir is one of the youngest at bar to have been conferred senior designation by the Gujarat High Court in 2019. He is the President of Income Tax Appellate Tribunal Bar Association, Ahmedabad, for the term 2015 to 2017. Sir has been a regular speaker at various conferences, seminars and meetings of varied professional bodies on diverse issues in the field of taxation and corporate laws. A regular writer of columns, articles and papers for professional journals and conferences, visiting faculty at various institutes, universities, colleges, management and law school on the subject of taxation and corporate laws. Sir has these and many more achievements to his credit. Sir, we are honored to have you here amongst us today. I extend a formal welcome to Sir Advocate Tushar Hemani, and I request Advocate Praful Shah, Governor Conference, to welcome Sir with a book. I would request one and all to please remain silent as we begin with this session. Let us please honor the dignitaries on the dais. Thank you, sir. I now request CA Ashish Tekwani, Vice President IT Bar, to come forward and welcome Senior Advocate Tushar Hemani sir with a memento as a token of gratitude. Thank you, sir. Senior Advocate Tushar Hemani sir, I humbly request you to come forward and enlighten us. I welcome you, sir. Please give a big round of applause to sir.
Good morning, friends. This has been an annual affair, as said by my predecessor speakers. And it is so very pleasant to once again see you all here. The topic given to me is 148, the burning topic of the day. I have exactly 1 hour available with me now, because 12:20 is time for the next speaker. So in this 1 hour, we'll try to unsolve the enigma which has been created by the government with the help of CBDT. And let me, without going into much of the technicalities, let us try to understand this problem from a simple layperson's point of view. Though I admit that laymen's, they get lost in the maze under the taxation laws, but nonetheless, let us try to understand the problem in a slightly simpler manner. What was the problem? Let us look at the problem, then we look at the solution. The problem was, it all started in 2020, March, to be precise, 24th March 2020. The entire world was affected by the virus COVID-19, and countries after countries went into lockdown modes so as to control the spread of this virus. India also was not an exception, and therefore India also went into lockdown. Because of the lockdown, the entire country came to a grinding halt. The activities came to a stop. Because the activities came to a stop, government thought that let us stop the clock also, insofar as large number of compliances are concerned. The clock was stopped by the government. Along with that stoppage of the clock, that limitation period running against the authorities in issuing various notices, including the notices for reopening, it was also stopped because everything came to a grinding halt. And thereafter, government came out with first the ordinance, thereafter the act, namely Taxation and Other Laws Relaxation of Certain Provisions Act 2020. And they said that everything, wherever any time limit is available, all those time limits, whether it is in favor of the SSE, namely for the purpose of investment, let's say some time limit is prescribed, be it that time limit or a time limit which was available to the assessing authority for the purpose of issuing various notices, let all those time limits get deferred. So every time limit which was there under any statute, including the Income Tax Act, they got deferred from time to time. This TOLA Act was operative till 31st December 2021 and thereafter 2020, and thereafter two notifications came to be issued wherein the due dates were extended from March to April and April to June 2021. So in a simpler language, the clock was stopped from 24th of March 2020 right up to 30th June 2021. This period was not to be considered for the purpose of limitation, and for the purpose of our today's understanding, that clock was stopped so that no notices were issued between this period or the notices which were required to be issued on broadly two milestone dates. One is 31st March 2020 and second was 31st March 2021. Because under the Income Tax Act, the notices for reopening, they usually expire on 31st March 2020. Therefore, on here slide is visible on this screen. Okay. Therefore, the question that all those notices which got time barred on 31st March 2020 and 31st March 2021, are they extended? Then the answer is yes. The notifications provided that the notices which were required to be issued on these two dates, 31st March 2020, 31st March 2021, could be issued up to an extended period of 30th June 2021. No dispute, no controversies, because this was well accepted by everyone. The twist came because the Parliament amended the law itself. Parliament came out with a new 148 scheme with effect from 1st April 2021. So the extension was under the old scheme. Old scheme, all the notices extended up to 30th June 2021. On 1st April, we have a new set of laws governing the reopening of proceedings under section 148, read with 148 capital A. And that is how the whole controversy started. That is the genesis of the controversy. That under the old law, there was an extension. Extension was up to 30th June 2021. However, Parliament came out with a new law with effect from 1/4/2021. Therefore, between 1/4/2021 and 30th June 2021, there were two parallel sections which were governing the issuance of notices. Now the question obvious is, how is this possible? Is it the choice of the assessing authority that he would decide that I want to issue notice under 148, the old section, or I want to issue notices under 148, new section? Because both the schemes were materially different. I'll make reference to that at a slightly later stage. But take it from me that both the schemes were materially different because there was a wide variance between the two schemes. Admittedly, it was a consensus amongst all the stakeholders that the scheme is not mere amendment or a minor correction in the old scheme. And therefore, obviously, question is which scheme would prevail? Assessing officer would be governed by which scheme? The old scheme as extended by notifications or the new scheme as introduced by the parliament? Almost again, the entire new regime which has come into force was operating, and during that operation, large number of notices came to be issued under the new scheme, under the old scheme. Assessing officer opted for extension of the old scheme. Therefore, he issued large number of notices, presuming that old scheme is extended up to 30th June and ignoring the new provisions of 148 as introduced by the parliament. Around 90,000 notices. I have picked up this figure from Supreme Court judgment. I do not have any authentic information on that, but around 90,000 notices were issued. All those notices came to be challenged before various high courts across the country, and various high courts ultimately held that when we have two schemes running parallel, the scheme which is later in point in time shall prevail. The scheme which is introduced by the parliament shall prevail. Here the old scheme was extended by way of notification, whereas the new scheme was introduced by the parliament. High Court held that the new scheme by the parliament, because parliament is the supreme body which can enact a law in the country, would supersede the notifications issued by the executives. Notifications, all of us are aware, are issued usually by CBDT. CBDT again gets the power to issue notifications by virtue of section 119. Section 119 again is enacted by parliament. Therefore, it is known as a delegated legislature, where parliament says that under 119 we allow CBDT to come out with certain notifications from time to time. So parliament's supremacy was unquestionable, accepted by the high courts across the country, that yes, the law declared by parliament being supreme would prevail over the notifications, and therefore the notices issued under the old scheme were completely illegal. They could not have done it. Allahabad High Court was the lead judgment, followed by Delhi, eventually followed by Mumbai, and thereafter followed by Rajasthan High Court, all with a speaking judgments. All the high courts nonetheless stated in no uncertain terms that we are quashing these notices issued under the old act because we believe that under the new act the notices ought to have been issued. However, we are not restricting the right of the department to take any remedial measures permissible under the new scheme if law allows them to take those actions. All those judgments of the high courts across the country were challenged before the Supreme Court. Supreme Court in the case of Ashish Agrawal took the view that yes, high courts are right when they say that new law, when it is already there in existence, the old law could not have been extended, number one. In absence of any such extension being allowed, notices issued under the old act are not valid. However, we believe that here revenue has made certain error in interpreting the notification. Because of the error on the part of the revenue, we do not want the exchequer to suffer. Therefore, we invoke the extraordinary provisions of Article 142 of the Constitution of India. Article 142 says that without going into the law which is laid down by the Parliament, in order to render justice to a citizen, it is always open to the Supreme Court to do or give any direction in whatever manner they deem appropriate. So by invoking Article 142, they said that let us do one thing. We find a middle solution. Rather than declaring that all the notices issued under the old act between 1/4 and 30th June as ex officio illegal and without jurisdiction, we might as well hold that those notices to be treated as a show cause notice under the new scheme. Under the new scheme, we all are aware that under section 148 capital A, small b is a show cause notice stage. So Supreme Court converted the notices issued under the old scheme, namely 148 notices where the assessments were actually reopened, into show cause notices under the new scheme. So Supreme Court said that you presume, though it is not written, you presume that all these notices are issued under the new scheme, because admittedly after 1/4/2021 new scheme has come into the statute book. Therefore you presume that these are all the notices which are issued under the new scheme. So far so good, not an issue. Supreme Court then goes one step further. Supreme Court says that once all these notices are to be treated as a show cause notices, we direct the authorities to supply all the material, all the evidences which are used for the purpose of issuance of this show cause notice. We direct the assessees to respond to these notices in a time-bound manner. We again direct the authorities to consider the show cause, replies and other material which is available on record to pass the final order under 148 capital A small d, D as in Delhi. Once that happens, then 148 notices, fresh notices can be issued. Supreme Court in the same judgment also observed, and mind you, this is how the problem has started. This is the first, I would say, the piece of the puzzle. And that puzzle, the piece of the puzzle, and that pieces of the puzzle, all those who have played jigsaw puzzle when we were young, we are given large number of pieces. And if you put the correct piece at the correct place, you get the correct picture. If you put it at a wrong place, you never get the correct picture. So this was one thing which was Supreme Court directed, that we are keeping all the defenses available to the assessees open. We are not foreclosing any defense, including the defense as regards limitation. So Supreme Court said that we are not foreclosing this issue at all because we are not commenting on the merits. We say that old notices to be converted into show cause notices under the new act, and those show cause notices can be challenged by the assessee on any ground, be it a factual ground or be it a legal ground. All the rights and contentions of the assessees are kept open, including the ground of limitation. And that is how all the notices came back. Revenue authorities converted those notices into show cause notices. Our replies were considered. Final orders under 148 capital A small d came to be passed. Again 148 notices were issued. And once again we realize that many of these notices are without jurisdiction on various grounds. And one of the major ground was with respect to limitation as regards 1314 and 1415. In the meanwhile, CBDT also came out with a circular adding more confusion to the already confused scenario. CBDT once again added confusion to the controversy by coming out with its own version of with a notification wherein Supreme Court said, CBDT came out with a notification wherein CBDT said that we read the judgment of the Supreme Court in a particular manner. Insofar as amount less than 50 lakhs are concerned, we accept the judgment of the Supreme Court for assessment year 13-14, 14-15 and 15-16. So if the cases of the SSAs were pertaining to AYs 13-14, 14-15, 15-16, and if the proposed escapement was less than 50 lakhs of rupees, CBDT said that we accept the judgment of the Supreme Court and we will not go ahead with the reopening proceedings. As regards 16-17, 17-18, we believe that this would fall within a period of 3 years from the end of the assessment year, because the time stopped on 24th March 2020. So therefore 16-17, 3 years would end on 31st March 2020. Supreme Court, CBDT said that time has stopped on 24th March 2020, and clock again started ticking from 1st of July 2021 by virtue of TOLA operating in between. Therefore, all our notices issued from 1/4 to 30th June 2021 would be deemed to have been issued on 31st March 2020 and for 17-18-21. So we consider both these years, 16-17 and 17-18, as being reopened within a period of 3 years under the new scheme, and therefore 50 lakhs limitation, which is beyond 3 years, would not be applicable, and therefore even if it is escapement of 1 rupee, will reopen 16-17, 17-18. 18-19 also was reopened in some cases, and therefore all those notices were once again issued back to the SSE. So we were all moving in circles. Initially we challenged the notices, High Court held the issue in our favor, Supreme Court having set aside the matters, we are again back to square one from where we started. We once again approached the High Court pointing out that for 13-14, 14-15, these are the notices which are issued beyond a period of 6 years, therefore no jurisdiction, it is barred by limitation. For 15-16, we raised defenses as regards no escapement, the escaped income not being represented in the form of assets. Either there is a change of opinion, if at all original assessment was framed under 143(3), or the source of information is not correct. Insofar as 16-17, 17-18, once again the issue was raised as regards two things. One, if the escape income is less than 50 lakhs, it is beyond a period of 3 years, and therefore those conditions are also required to be satisfied. And as regards the sanction under section 151, it was raised, the issue was raised before the High Court that all these notices are issued without the sanction contemplated under 151 subclause 2, namely of a higher authority, where the period of reopening is falling beyond 3 years. Once again, hearing took place before various High Courts, and now fortunately we have the judgment of Gujarat High Court as well as Allahabad High Court taking a view in favor of the SSE in the second round. What is the view which is taken by Honorable the Gujarat High Court? Gujarat High Court in the case of Kinara Industries recently decided the issue in favor of the SSE. The decision was only for assessment year 13-14 and 14-15. It was not for any other year. Therefore, this law, which is laid down by Honorable the Gujarat High Court, is applicable only to 13-14 and 14-15 and not to any other years. However, the observation made in the judgment are noteworthy, and based on that, probably one can argue that even 16-17 and 17-18 are also without jurisdiction. So what is the position today, before I take you to the judgment per se and the law on the issue? What is the position today? There are broadly two classes of pending cases today. One class of pending case is pertaining to a period where the notices were issued between 1/4/2021 and 30th June 2021, where the assessments were ranging from 13-14 right up to 18-19. That was one class of SSEs where the notices were issued in the first round between the first quarter of financial year 21-22, and the second class of notices, which are again challenged before the court, are pertaining to the notices which are issued after 30th June 2021, where the fresh notices are issued, and those years are ranging from 15-16 onwards. Therefore, two different arguments. Supposing today you are concerned with a group 1 matters, namely the matters where the notices were issued in the first quarter of financial year 21-22, 1st April to 30th June 2021. All those assessments are getting time barred now. Either on CBDT says that it has to be by 31st of May 2023 earlier. Now informally they have stated that all those orders are required to be passed immediately, as early as possible, and latest by 31st March 2023. So today, if you have not challenged the matters immediately before the High Court, what are the defenses which are available to you? If it is 13-14, 14-15, my advice is straight away go and challenge the matters before the High Court, because High Court is now seized of the matter. High Court knows that 13-14, 14-15 are beyond limitation period. Supposing it is 15-16 onwards, right up to 18-19. If you believe that AO has acted without jurisdiction, this is the time that you have to decide, take a call for yourself, that whether to go ahead with a writ petition or to defend your case before the Commissioner of Income Tax appeals in the regular appeal proceedings. The way in which I would put it is this wise, that broadly for 13-14, 14-15, limitation would come to your rescue. For 15-16, keep in mind that 15-16 is already treated as an assessment which is beyond a period of 3 years, even by CBDT also, even by revenue officers also. Therefore, you will find that for 15-16, all the notices which are live today are all having an escape income in excess of 50 lakhs of rupees. Therefore, that defense will not be available to you for 15-16. Secondly, because the CBDT, revenue authorities themselves have taken these notices to have been issued beyond a period of 3 years, the sanction is taken of an authority contemplated under 151 subclause 2, namely of a principal chief commissioner and equivalent authority. Therefore, even that ground is not available to you. Then how do we challenge these notices for 15-16? 15-16, the ground which is available to you is pertaining to the escaped income being represented in the form of an asset. Under section 149, 1 says that any reopening which is taking place under the new scheme are broadly classified under 2 categories. 1, reassessment being taken within a period of 3 years from the end of the assessment year. There are no further conditions. So only condition is escapement of income. The moment there is an escapement of income, within 3 years, even 1 rupee escapement, revenue technically has a right to reopen. However, 15-16 being beyond a period of 3 years, will fall under clause B. Clause B, as existed between 1st April and 31st March 2022, had 3 conditions. The first condition was that assessing officer must be in possession of books of accounts or other such evidences. Number 1. Number 2, by reading of books of accounts or other such evidences, there must be an escapement of income. Number 3, that escapement of income must be represented in form of an asset. And number 4, the value of such escaped income proposed must be equal to 50 lakhs or more than 50 lakhs. The term asset was defined under the statute. Explanation to 149 defines what is asset. Asset is broadly classified under 7 different heads. Land, building, or both. Therefore, first is immovable property, land, building, or both. Second was shares and securities. So 2 shares or securities, immovable property. Third was loans and advances. So book entries, loans and advances are by and large book entries. And the 7th category was in terms of any deposit in the bank account. Now, if you believe that the proposed action for assessment year 15-16, wherein the allegation against you is pertaining to an escapement which is arising because assessing officer has books of accounts or other documents. Probably other documents would cover all kinds of information shared by the investigation wing. Therefore, probably that condition would be satisfied in almost each and every case. Based on that, there is an escapement. I'll come to escapement slightly later in point in time, because that's again a complicated argument. Must be represented in the form of an asset. Yes, this is where 1516 immediate defense would come to your rescue. You find out what is the ground for reopening for 1516. Large number of cases, the ground for reopening in 1516 is pertaining to A, your stock market gain on the floor of the stock market, namely long-term capital gain claimed as an exempt penny stock gain. Second is you have taken some money, some share capital, some loans from a known entry provider who is raided and from whose information has emanated, and that information is disseminated to all the concerned authorities. Third is based on some additional information, namely based on the information which is collected from the bank, large number of cash transactions, based on the information which is collected from stamp authorities, property transactions, 50C, etc. All those are falling under third category. So broadly, these are the grounds based on which 1516 is reopened. Now you put a question to yourself that does any of this ground, the underlying ground, can be treated as an asset? If the answer is no, you certainly should challenge those matters before the court of law. Supposing, let me take an example of a capital gain. Let's say that I have earned certain capital gain. If that capital gain is the ground on which there is a reopening, therefore the ground is that long-term capital gain, which is according to the revenue authorities, is not correct. This is nothing but a fictitious entry or an accommodation entry whereby you have taken that entry from the entry provider. Someone is manipulating the stock. You have given cash to that person and that person has given you a gain by way of an entry. And that entry is now sought to be taxed by the revenue authorities. Therefore, the argument is that can that entry in your books of accounts be treated as an asset? Because it is admittedly not shares and securities. Shares and security you have sold. This is not pertaining to shares and securities. Therefore, the question is, can it be said to be falling within the definition of asset? The argument usually raised by the revenue is that, sir, what about the money which I receive from the stock market? I sell the securities. On a payout day, I give the securities. On a pay-in day, I receive the money from the stock market. I receive the money from the stock market. And that money is admittedly deposited into the bank account. If that money is deposited into the bank account, can I not say it to be falling within the seventh limb of the definition of asset? Seventh limb is any deposit in the bank account. Because that is the argument which is used against me by the revenue authorities. That's a deposit in bank account includes anything. However, there the question of interpretation would come. And what is that interpretational issue? The interpretational issue is going to be, and again going to be decided by some court at some stage. I understand Bombay High Court has already started the hearing, and since last more than 20 days the hearing is going on a piecemeal basis. And one of the issues which is going to be decided is this. But then the argument is that when I am interpreting the term asset, there are 7 categories of asset. Bank deposit per se is not an asset. And therefore only those deposits which are having the characteristics of an asset can be considered as bank deposit. Otherwise even bank loan also would, one leg of bank loan is always bank deposit, because bank would give me money, I'll deposit in my bank account. Or for that matter, I take loan from anyone and deposit in my bank account. If that deposit becomes the asset, then in fact all the Malias and Modis would be very happy, because they would say that, sir, this is asset, not a liability, therefore we don't owe anything to the banks. Therefore anything which is deposited would not partake the characteristics of an asset. And there is a well-known principle of interpretation, eius dem generis, where the law says that you are known by the company that you keep. So other words appearing in the asset would throw light as regards the interpretation of the term deposit in the bank account. Therefore, this is one argument, namely whether the escape income is represented in the form of asset or no, that is available for 1516. The second argument, of course, is that supposing 1516 is already scrutinized and the very ground on which you are now sought to be reopened has been put to you during the course of the scrutiny, you can always raise that as a defense, that this is a change of opinion. Argument many a times is that, sir, now there is no reason to believe and therefore there is no change of opinion concept. To me, that argument is not correct. For the simple reason that change of opinion had nothing to do with reason to believe. Change of opinion is a derivative of the argument that there is no power to review available to the assessing authority. When there is no power to review, there is no question of change of opinion. It had nothing to do with reason to believe. Reason to believe is a question of belief. We are not talking about change of belief. We are talking about change of opinion. And opinion was the framing of the original assessment order and acceptance of your version which you put before the then assessing officer. Because the authorities did not have a power to review, there is no question of change of opinion now. The third argument which you can raise in 1516 is that, sir, what is the source of information? Supposing source of information is that while framing the assessment of some another assessee, we realize that you have lent huge amount of money to that assessee. We would like to find out what is the source of that money in your hand. Now, certainly, now the new scheme is driven by information. Entire reopening process is information driven reopening process. And the source of information is not kept wide open. The source are all defined under 148 explanation 1 and explanation 2. Explanation 1 defines during the 21-22 only 3 sources of information. After 1/4/2022, 5 sources of information. Information during 21-22, it was having a truncated definition, and the other assessing officer giving a finding was certainly not part of the source of information. Therefore, 1516, even that argument is available to you. We come to 1617 and 1718. We are taking these 2 years combined. 1617, 1718, the major argument is twofold. The first argument is revenue authorities have treated it as a reassessment within a period of 3 years. Their argument is 1617 last date was 31st March 2020, 1718 last date was 31st March 2021 for the purpose of counting 3 years. They said that the clock stopped for this period between 24th March 2020 and 30th June 2021. Therefore, we treat this as having been issued within a period of 3 years. In the CBDT circular post Ashish Agrawal, paragraph 6.1 said that there was a time travel mechanism available to the department, and department travels back in time to issue these notices at the relevant point in time because the time has stopped. Gujarat High Court in Kinara Industries has categorically rejected this argument. Gujarat High Court said that there is nothing like time travel. The clock remains active all throughout, and therefore you cannot say that these 2 years also the reassessment notices have been issued within a period of 3 years. The moment I say that these are the notices which are issued beyond a period of 3 years, I fall under clause B of 149(1). Clause B, as I indicated earlier, have conditions. One of the condition is 50 lakhs of rupees, and second condition is that under 151 the sanction is required of a higher authority, because within 3 years a lower authority can sanction, beyond 3 years a higher authority is required. Therefore, these 2 arguments are going to be decided. Probably the court has fixed the matters on Monday itself. On the last week we argued this matter briefly. Court is prima facie convinced that it is covered by the judgment of Kinara, and therefore 1617, 1718 also Gujarat High Court is going to decide most probably on Monday itself. So therefore these 2 defenses are available to you: 151 sanction, and secondly, if it is less than 50 lakhs, then you can straightway say that this is beyond 3 years and I don't have to look at anything else. If it is less than 50 lakhs, you don't have any jurisdiction, come what may. That apart, whatever defenses that are indicated for 15-16 would also be available for 16-17, 17-18. For 18-19, the only defense probably that is available to you is there any escapement of income and is there any change of opinion insofar as 18-19 is concerned. So therefore, this is broadly the issue which is at large today. Now with this, let us look at Gujarat High Court judgment. Gujarat High Court has recently, judgment was made available last Sunday, decided the issue, and what is more prominent is that court has laid down that Delhi High Court was not correct. The judgment of touchstone, wherein a contrary view was taken, was not correct because the Delhi High Court proceeded on certain wrong premises. High Court said that the limitation is something which is very, very important, and if the notices are issued beyond limitation, court would show its indulgence and entertain the rates and cost the notices there and then only. The court further says that while deciding the issue as regards the supremacy of Parliament, all the notifications would go into oblivion because those notifications cannot go against the wisdom of the Parliament, and therefore High Court has re-established or reiterated the supremacy of the Parliament. In view of that, Gujarat High Court said that we do not accept the theory of the revenue authorities when they say that time travel happens and we go back in time to issue the notices at the relevant due dates, because according to the revenue authorities, TOLA has stopped the times. Now that is also explicitly rejected by the Gujarat High Court insofar as the judgment of Kinara Industries is concerned. Gujarat High Court says that in fact the judgment in the case of Ashish Agrawal of the Supreme Court helps various courts while interpreting the provisions of limitation. Ashish Agrawal said very categorically that all the defenses, including defense of 149, is available. If Supreme Court believed, and that too so strongly, that new notices are not required to satisfy any test of limitation, the court would have straightway converted those notices which were there before Honorable the Supreme Court into notices under 148 under the new scheme. Why? What was the need for the court, Supreme Court, in the case of Ashish Agrawal, to convert those 148 notices into show cause notices under the new scheme? Rather than show cause, they could have converted into final 148 notices. That itself shows that Supreme Court was conscious that there are large number of limitation issues which are required to be decided, and therefore Honorable the Gujarat High Court said that we have to look at that intention of the Supreme Court also. Immediately after the Gujarat High Court judgment, now we have the judgment of Rajiv Bansal in the case of Allahabad High Court. Again a recent judgment, last week's judgment, wherein again a similar view is taken. Here the notices were between 13-14 to 17-18. All those notices Allahabad High Court held that are not valid for the simple reason that 149(1)(b) proviso would prevent the revenue authorities in issuing these notices beyond the limitation period. Therefore, now we have two judgments wherein the view that is taken is that revenue was not correct when they issued the notices en masse, 90,000 notices in the first quarter of financial year 21-22. That would take me, let me now in a hurried manner, in a slightly faster manner, look at the scheme so that as and when we are faced with class 2 SSs, I indicated earlier that class 1 was the first batch of cases where notices were issued between April and June 21. And class 2 is any notices which is issued after 1st July 2021. So today there is a notice which is issued against you. Then how should we proceed in creating a defense which would ultimately help you in succeeding at a later stage? Look, the intention of the law is to reduce the litigation. Parliament, Honorable Finance Minister, while introducing these provisions, have very categorically stated that the idea is to reduce the litigation and bring in certainty. Kindly have a look at the language of the two acts. And this makes a very interesting reading. Eventually, again, some court will decide someday that what is the significance of the removal of the word reason to believe. Because if you look at the entire phraseology of opening words of both the section, old and new, you would find that except for removal of reason to believe and some grammatical adjustment, the contents have remained the same. Look, here the old language was, if the assessing officer has reason to believe that any income chargeable to tax has escaped assessment for any assessment year. As against that, now the new law says that if any income chargeable to tax, now income chargeable to tax appears in the old law also. In case of an SSC, has escaped assessment, again earlier part also escaped assessment for any assessment year. Therefore, if you compare this minutely, the only thing which comes out is reason to believe is removed. Now, reason to believe, we all are aware that that's a highly subjective process. I may have reason to believe because my belief is based on certain reasoning. Everybody has a different set of beliefs, and those beliefs are always based on some objective criteria, though belief may be subjective. And therefore, in order to take out this subjectivity from the entire process, the reason to believe is now removed. You don't go by the belief of the assessing officer, you go by the escapement of income. If there is an escapement, because escapement of income is incapable of having two interpretations, two different beliefs, because there is no question of any personal belief. Therefore, the most important is, whenever Parliament deletes a word, does there any significance which can be assigned to that deletion? Supreme Court said in the case of 9 SCC 548, that is 2020 9 SCC 548, Supreme Court says that whenever Parliament deletes a word, you have to assign some meaning to that deletion. You cannot simply say that Parliament ne lagyu એટલે word કાઢી નાખ્યો, એવું ના હોય. There has to be every word which is inserted, altered, deleted or modified in any manner by the lawmaker has to have some meaning assigned to it. Otherwise, Parliament would not alter the section just for the sake of altering it. Therefore, we go by the deletion and we have to assign some meaning to it. And the only meaning which I can assign is that the Parliament wanted to take out the revenue subjectivity, the revenue subjective belief insofar as reason to believe was concerned. And therefore, what remains? What remains after the removal of the belief is escapement. And therefore, whenever you are faced with a reopening notice in the new scheme, the first emphasis should be that where is the escapement? In what manner the escapement is established? Because earlier it was mere belief, and I may have believed that based on looking at certain things, this belief is justified. Court would always look at the existence of the material insofar as formation of that belief is concerned. Court would not go into the sufficiency of that belief. Therefore, looking to the clouds, I would say that it is going to rain cats and dogs. It is going to heavily rain. And therefore, that is my belief. Someone might challenge that belief before the court of law. Court would say that all right, clouds are there. And therefore, there is a reasonable ground for the purpose of belief. However, sufficiency, my belief is it's going to rain heavily. Someone might not agree with me and might say that no, sir, it's going to rain only drizzle. There is not going to be heavy rain, no need to rush home. Office માં રજા નહીં મળે. એટલે that court will say that will not go into sufficiency. We'll only look at the black clouds and yes, there is a possibility of rain. Therefore, that is sufficient for us. We'll throw you out there. Here is where the new language would help you, and that is where you have to say that no, sir, now it has to be established that it is going to rain. Your belief is not sufficient. You establish that because in last 10 years, whenever in the month of February there were black clouds, it rained in the very next hour. Therefore, it is going to rain. That something, it has to be established. And that is where probably we can create large number of defenses. The proviso, deletion of third proviso 147 again is going to open a large amount of litigation, and that is whenever a subject matter is, the underlying matter of reopening is a subject matter of further appeal, reference or revision, no reopening. So merely a filing of appeal is sufficient because it's a subject matter of appeal. As against that, 263 says that it has to be decided. Therefore, the deletion of third proviso, where you get protection that the original stage, some issue was touched, that issue is further subject matter of appeal. Even if the appeal is not decided, you can't reopen because of the third proviso. Now it is taken away and you have to fall back on the principle of merger as generally understood. And generally understood principle of merger comes into play, gets triggered only when the order of the lower authority, when taken into further appeal, appellate authority deciding that appeal, the order of the lower authority merges into the order of the higher authority. That is known as merger. Now pending appeal, the principle has no application. There is no merger because appeal is still pending. Here proviso 3 was protecting the SSEs. Now that protection is not available. Dimmed escapement, again an interesting concept. Large number of situations were dimmed as an exception. There was a provision under the Act, under the old scheme, explanation 2, which would contemplate large number of situations. And those situations would be treated as a dimmed escapement. Now that dimmed escapement is not there, and therefore all those situations where there was a dimming provision, where the dimmed escapement was there, one has to argue that, sir, we needed a dimming provision under the old Act so as to establish the escapement. Therefore, admittedly, these situations per se on their own cannot have a meaning which is equivalent to escapement of income. Because if these situations itself, let's say non-filing of TP report was one of the situations which was contemplated to be having a dimming force for the purpose of establishing the escapement. Now, if no TP report is filed, and if they say that there is an escapement, we can argue that, sir, there was a dimming provision earlier. Now there is no dimming provision. And if by not filing of TP report, escapement is automatic, then what was the need of dimming provision under the earlier Act? Because then something which is obvious, you don't need a dimming provision. Dimming provision means something which is ostensible, which is visible, is not correct, but you have to presume something different for the purpose of operation of the law. Now, for that reason, you can invoke the dimming provisions. 148 is a procedural section. However, 148 can come into action only when two conditions are satisfied. One is that there has to be a suggestion to the effect that income chargeable to tax has escape assessment. And second is, the notice must be issued after obtaining the approval from the authorities prescribed under 151. Now, the term, phrase, suggestions as regards income chargeable to tax is again going to be a hotly litigated section, a hotly litigated phrase. Because what is the meaning? Kindly have a look at, yes, explanation 1. Explanation 1 defines what is the information with the assessing officer which suggests that there is an escapement of income. Now, what is the meaning of this? Explanation 1, it prescribes 5 situations. Earlier it was 3, now it is 5. So what does this explanation say? Does it say that these are the information which can suggest that there is an escapement, or these are the information wherein suggestion is embedded so as to straightway jump to the conclusion that there is an escapement of income? I hope I am clear. Let me look at the bold portion. What is explanation 1? Explanation 1, does it indicate only the information and the suggestion as regards escapement of income is left to the discretion of the assessing authority? Or explanation 1 talks about information which itself contains the suggestion as regards escapement of income? Because if the second letter is accepted, that these are all informations having an embedded escapement of income, then mere existence of this information would grant jurisdiction to the assessing officer. The moment there is, let's say CBDT, risk management strategy, the moment something appears on the portal itself is sufficient to reach to the conclusion that there is an escapement of income. Or the portal information is just an information based on which AO has to use his brains and derive the suggestions as regards the escapement. Now, again, court will have to examine these aspects and determine. My respectful, humble opinion is that these are all information. The process of deriving escapement is left to the assessing authority. So, mere existence of information itself would never suggest that there is an escapement of income, and that is the reason why we have the proceedings under 148A, 148A, B, C and D. Show cause, replies, final order. That is the process by which AO would convert this suggestion into the escapement. And therefore, suggestion is to be read, interpreted, analyzed by AO on a case-to-case basis. He cannot say that by virtue of explanation 1, the moment there is existence of information, it is itself is having a suggestion that there is an escapement of income. Therefore, it is not automatic. Explanation 2 is also on the same grounds. 2 talks about search and survey actions, etc., which is event based. Explanation 1 is transaction based. You enter into a stock market transaction, gets reflected in the risk management strategy, CBDT portal, he picks up the transaction, or you enter into 135A transactions, or there is a transactions vis-a-vis a multinational company falling under article section 9090A. All those are transaction based deeming fiction. Explanation 2 is an event based deeming fiction, where search an event, survey is an event, third party search an event. Based on that, again the accrual is of information. Information again has to be analyzed and explained, used by the assessing officer for the purpose of deriving suggestion from that information. Change of opinion I have already covered. 148 capital A, again procedural aspect I have covered that. Now let me deal with the last aspect as regards 149 and interpretation thereof, because 149 is very interesting. 149 talks about a limitation. 149 says that no notice under 148 could be issued unless following are satisfied. Then subsection 1 small a says that within a period of 3 years escapement. So only escapement you get jurisdiction. Clause B says, as I indicated earlier, clause B says that there must be books of accounts, other documents or evidences available with the assessing officer. Those books of accounts, other material evidences must reveal that escape income is represented in the form of now, today, in the 3 broad formats. One is asset. Of course, we have already discussed asset, therefore no need to go there again. Second is expenditure insofar as a transaction, insofar as an event or an occasion is concerned. So, not any expenditure. Expenditure vis-a-vis a transaction or an event or an occasion. So, expenditure is also given a truncated meaning. And last part is any entry in the or entries in the books of accounts. So, any entry or entries in the books of accounts would cover all those entries, namely accommodation entries, all those capital gain transactions. So all that would be covered under the broadened purview of 149 1B third part. However, what is still not covered, let me indicate what is, according to me, what is not covered even under this. Supposing there is a search at a builder's premise, and during the course of the search a builder's diary is found out. Builder's diary is found out. And in that diary, on money transactions are written. The builder has collected on money from various clients when he sold the properties to them. So therefore, on money transactions are there in the diary. Therefore, I go back to 149 1 small b, because here the year is beyond 3 years. Admittedly, the amount is more than 50 lakhs of rupees, because few crores were collected. Therefore, I go back there and try to find out, does the assessing officer has the jurisdiction? Books of accounts or other documents or evidence? Probably it is not books of accounts, but the other documents and evidence is diary would the definition of other documents and evidence. Now, escape income on money, represented in what form? Is it an asset? Asset, 7 classes. We have already discussed 7 classes. Land, building, shares, securities, loans, advances and deposits in bank account. This is a transaction in cash on money. Therefore, it is neither land nor building, neither shares nor securities, neither loans nor advances nor deposit in the bank. Therefore, not an asset. So we go to the next category. Is it an expenditure with respect to a transaction? Answer is no. Is it expenditure with respect to an event or occasion? Answer is no. I go to the third category. Is it an entry or entries in the books of accounts? Answer is again no. If it is part of books of accounts, it can never be on money. On money means it is something which is not part of my books of accounts. It is outside the books of accounts. And therefore, where do I put this? Admittedly, there is an escapement of income. Now the law is information driven. Now the law says that if I fall under clause B, then only assessing officer gets the jurisdiction. And how would he get the jurisdiction? My respectful and humble opinion is that he would not get the jurisdiction unless the law is appropriately amended. That would take me last proviso, because I'm almost 12:20 and I can see Manish sitting over there patiently. So my turn is coming to an end. So last proviso. How do we interpret this proviso? Proviso is basically, it restricts the operation of 149. 149, it says that no notice could be issued unless 3 years and from 4th to 10th year different criteria. Assuming that I fulfill those criteria, then I go to the further exception carved out by the proviso. What does the proviso say? Proviso says that in case if the limitation under the erstwhile act has already expired, by virtue of a longer limitation period now being available under the new scheme, would not allow the authorities to reopen because a longer period is available. Earlier scheme, we all know that there was a 6 years outer limit for the purpose of reopening, unless certain exceptional circumstances, it was 10 and 16. But 6 years was a norm. So 6 years for the purpose of new scheme, the 6 years became 10 under clause B. It is now 10. Therefore, year number 7, 8, 9 and 10 are 4 additional years which are available to be reopened the moment there is an introduction of the new scheme. And that is where the proviso comes handy. Proviso says that you cannot reopen those years where the proceedings have expired, where the proceedings have become barred by limitation. And you cannot revive those years merely because now you have a longer duration for the purpose of reopening. Earlier it was only 148 read with 149. Thereafter the law is amended retrospectively and 153A and 153C are also inserted into the statute book. There is one interesting controversy, again someday courts will decide before I conclude, and that interesting controversy is that under 153A and 153C also, the outer limit is 6 years. Unless, if you remember 153C and 153A, outer limit is 6 years ordinarily, because the moment there is a search, 6 years would get reopened. However, if during the search, any asset is found out, and if that asset is having a value in excess of 50 lakhs of rupees, 4 more years can get reopened under 153A, 153C. Those are known as the relevant year under the old scheme. Now, relevant year, the only triggering condition is asset in excess of 50 lakhs. Interestingly, there also asset is defined as the 7 heads which I discussed. Only asset it can get the jurisdiction for the purpose of reopening even under the old scheme. So supposing if a builder's diary is found out, again builder has a notoriety for maintaining a diary, and diary keeps us all going. It generates a lot of litigation. So builder has a diary wherein he has recorded unexplained expenditure which he has spent for the purpose of construction in excess of 50 lakhs of rupees. Year is falling 7th, 8th, 9th and 10th year. Here the law says that he can get jurisdiction only if under the old scheme there was a jurisdiction, and under the old scheme there would not be any jurisdiction, because there the only trigger condition is asset and not expenditure, which is now available here under the new scheme. And therefore, even while reading the limitation under the old 153A read with 153C, you find that 6 years and only asset criteria is there. So with this, friends, I am through with my presentation. Probably all the issues are covered, and if at all any questions are there, I can do it in 2-3 minutes, otherwise call it a day. I take it that there are no questions. Friends, I thank you all for giving me a patient listening. Jai Hind.
Thank you, sir, for making it simpler for us to assemble the puzzle pieces. At this instance, we would like to felicitate the committee members for their sheer dedication and zealous efforts at the hands of our eminent speaker, Senior Advocate Tushar Hemani, sir. Sir, may I request you to felicitate Advocate Praful Shah, sir? CA Ashish Tekwani, sir. Advocate Anil Shah, sir. Advocate Anil Shah, sir. CA Suvrat Shah, sir. Advocate Dipesh Shakwala. CA Kenan Satyawadi. CA Nisha Tekwani. And CA Chola Thakkar. We thank you, sir. Here we come to the end of the first technical session. I invite the dignitaries on the dais to come forward for a group photo session. We now begin with our second technical session to be delivered by Advocate Manish Shah, sir, on challenges under the Faceless Assessment Scheme and fundamental of principles of natural justice, PR.